Afternoon, everybody. Hi, you know me, I'm Herschel Conyers and the current chair of JJI. And I think we've got something really exciting going on here today. So I want to introduce the three people who will be presenting from the National Juvenile Defender Center. Jamie Michael, who is the research manager, Carly Linoff as the research fellow, and Marianne Scally as the executive director. And they have spent since 2020 putting together this report that they are going to share with us today. They have interviewed public defenders from some 50 plus public defenders from some 38 states. The report is heartening and depressing at the same time, which is the space we often find ourselves in. But I want to thank them personally for the efforts and putting out there what I think some of us know. And they will report, we'll do some Q&A, and we'll do some breakout where we can try to take a deeper dive into this issue. So without more due process in the time of COVID, lessons and reflections. Thank you, ladies, for being with us today.
Thank you. Thank you for asking us. So again, we're here today to present our findings from a study we conducted last summer during the pandemic. The purpose of the study was to investigate the impact of COVID-19, the pandemic, on the experience of juvenile defenders and their clients. We began conceptualizing the project back in May of last year. So the pandemic started in about mid-March. And after a couple months, we heard a lot from defenders in the community who were really struggling with all types of challenges that the pandemic presented for representing their young clients. And so we wanted to figure out a way to systematically investigate that, to capture what those issues were so that we could figure out ways to better support juvenile defenders, both during the pandemic and after. Oops. So in terms of our study goals, the first goal was really to highlight the experience of juvenile defenders as first responders. The role of juvenile defenders is to advocate on behalf of their clients, in particular their clients' liberty interests. During a pandemic, there's more at stake than liberty interests. Health is at stake, particularly for young people with preconditions. Yet advocating for their clients, for defenders, meant that sometimes defenders had to put themselves at risk for contracting the virus, passing it off to their family, or even passing it back to clients or other clients. I remember just one point here, there in one of the interviews, there was a comment from a defender sort of drives this home. And he was talking about how just it's kind of crazy, the calculus that kind of had to go through his mind when thinking about whether or not to take a client, take a case to trial, to in-person trial, and that it came with an enormous risk to both his health and safety and the health and safety of his client. And that had to be a part of their calculations in taking a case to trial. So we really wanted to hear from defenders what were the health and safety issues that they were experiencing and the health and safety issues of their clients. And to highlight this idea that defenders during this pandemic and even sort of beyond the pandemic were really working as first responders and helping youth navigate this crisis in the court system, in the delinquency system. We also wondered how the pandemic, we wanted to hear from defenders how they thought the pandemic was perhaps magnifying disparities that already existed in the delinquency system. And also how issues of equity might play out in regards to this shift to remote operations, to remote justice. And finally, our last and probably one of the biggest study goals was we were concerned with how this shift to technology-based communication would impact legal representation. Pre-pandemic, there were jurisdictions that used video conferencing in juvenile court. We were aware of this. And as an organization, we have always been critical of the use of video conferencing in juvenile court. Usually in our discussions, or I think there even have legislative testimony about this, talked about legal arguments, but they've been primarily legal arguments. And also sort of talking about the technical difficulties, right? Just highlighting the technical difficulties that can occur when a defender is trying to represent a client who's not in the same room, or if the defender is in the same room with the client, how the defender, the conflicts that can come up, or the technical difficulties that can come up when the defender isn't in the same room with other court stakeholders. And so as we were conceiving this project, right in the midst of the pandemic, when the whole world was turning remote and having to really struggle with how do we do this, and what are we losing out on when we switch to sort of technology-based communication, we realized that there was more recently had been research conducted on this field of what's called mediated communication. And I believe, Carly, that there are a few pieces that we will put in the chat for folks. A couple pieces from the NLADA, another defender organization for adults, and the Brennan Center. And they're essentially reviews of some of the empirical research on video conferencing. Now, interestingly, there's not a lot that's been done in the legal context. There are a few studies looking at immigration, looking at bail, but most of the research that really talks about the process, right, or how it's different between in-person and technology-based communication, they're mostly done from in the business world. So there's these experimental studies looking at business issues or business problems. So like interviewing for positions, or collaborating. I think collaborating is definitely probably one of the main sort of topics in this research field. So what these studies, interestingly, have shown us, are what we started to learn as we were looking at the studies and talking to researchers, is that when we are communicating, there are these nonverbal cues like eye contact, like body language, like tone, and we attend to those when we're communicating with somebody, and when we're doing it through technology, so through a computer, through video conferencing, or through a phone, they're different. We don't attend to, in fact, we don't attend to the same cues, or those cues are limited or distorted when we are communicating via technology. So it is different, and there is something that's lost. And these cues really impact how we perceive people, how we judge people. And so they're important. So we wanted to understand from defenders how they were experiencing this shift to technology-based forms of communication, especially video conferencing, and how they felt it impacted their ability to effectively represent young people in the courts. So in regards to our methods, again, this was a qualitative study. We interviewed 51 juvenile defenders from 38 different states, including DC and Puerto Rico. And these were all folks who were part of the NJDC network. They were all specialists in juvenile defense. And we really, really thought that this group of people could really help give us some important insight into just the experience during the pandemic, and how it was affecting how they represented young people in the court system. We did phone calls, 45-minute interviews conducted by phone. We had about 11 open-ended questions. The questions were fairly generic. And we didn't ask folks things like, do you see yourself as a first responder? We generally just sort of asked if they had any concerns about their own health and safety when they were representing young people, or if they, and what the concerns were for the young people, what concerns they had for the health and safety of young people, and what the young people were saying themselves about what was concerning them during the pandemic. And we also, again, in the same thing with technology-based communication, we didn't specifically ask what their obstacles were that they experienced. We just asked, how has communication changed during the pandemic? How have court procedures changed? And how do you feel about those changes? So we really wanted to kind of just leave it open to hear what folks were experiencing without sort of our bias there judging their perceptions or their experience. So they could just sort of give us their opinion, their honest opinion of what they were experiencing. And there were a lot of differences all over, because some people were experiencing a hybrid environment where some court hearings were in person, some were remote, some were entirely remote, and some were still in person. So there were definitely a number of experiences, but by far, when we did the analysis, the key themes that emerged was that, first of all, the issue of this idea of first responders. There was a lot of discussion around the health and safety risk, both to themselves, but mainly concerns for the health and safety of young people during the pandemic. And the other key theme that emerged most frequently was this struggle with technology-based communication and how it negatively impacted the representation of young people during the pandemic. So it's this, because that's the topic for our talk today. Carly is going to go into our findings, but really focus on the findings regarding what Defender's experience was with technology-based communication and how they felt it impacted their ability to provide effective representation for young people. So Carly.
Thanks, Jema. So when we talk to these 51 defenders and when we talk to them about virtual solutions specifically, one theme that ran through almost every single interview, if not every interview, was this one. And one of the defenders we interviewed just summarized it so eloquently. I didn't want to change anything they said about it. I just wanted to use their words. And that's that virtual solutions presuppose that a young person has an email, access to video conferencing applications or software, the means to obtain the tools necessary for appearance, and technological savvy. Technology-based communication presupposes a position of privilege. And this defender was speaking specifically to something that in research is typically referred to as the digital divide. Now, the digital divide is a term that refers to the gap between those who have access to broadband internet and the technology to actually use that broadband internet effectively versus those who do not. And research has demonstrated that just as a matter of statistics, Black and brown communities, rural communities, and communities that have lower socioeconomic status tend to, just as a matter of fact, not have robust access to these types of things. And these are three pretty broad types of communities, but these are communities that I think we all know a lot of our clients, a lot of our youth come from. And so it puts individuals who live in those communities at a distinct disadvantage when it comes to communicating through technology-based means. And our field is one that trades pretty extensively on communication. So as a result, being on kind of the short end of the digital divide puts individuals at a distinct disadvantage when it comes to engaging with the legal system and remote justice specifically. Defenders specifically cited issues around confidentiality, around just technical limitations that may have predisposed them to ethical issues, and also just the ability to connect with clients and other court stakeholders on a human level. So let's start with that first point that I touched on. Just attorney-client communications. And we know that rapport building is very important, particularly for defenders with their clients. And rapport building starts in the field. You can't build rapport unless you're talking to the person you're trying to form a relationship with, right? And as a lot of defenders that we spoke with, most defenders that we spoke with really noted that simply even just getting in touch with clients was difficult. Either clients lacked devices, or if they did have a device like a phone or a tablet that allowed them to communicate electronically with their defender, those devices lacked reliability, either a bad connection, no camera, no minutes. It was difficult for attorneys to get in touch with their clients. When defenders could get in touch, the opportunities for contact were tended to be less personal, or were described as less personal and less confidential than those that would have been done in person. And this became a very important point for ensuring confidentiality. Confidentiality is a pretty unique tool in an advocate's toolkit when it comes to building trust in clients, especially when you're engaging with younger clients. And defenders repeatedly expressed frustration to us when being interviewed that they found it difficult to ensure confidential communication. They couldn't control the environment. They didn't know for sure who else was in the room outside the scope of the camera. And this was repeatedly raised, particularly with regard to youth in secure facilities. Defenders expressed concern that correctional officers would insist upon remaining in the room if the youth was going to be using facility computers to have a video conference call, or even if they were just on the telephone. Adult gatekeeping of communications or intrusion into confidential conversations was also an issue for youth not in custody, especially if the youth didn't have a phone, but their parent or guardian did. But this was very much a really striking concern for defenders who had youth in custody and who really needed to be able to have frank and confidential conversations with their clients that they didn't feel comfortable having because they didn't know who else was in the room. And so this overall decrease in attorney-client communications, as well as some of the expressed feelings of reductiveness or impersonality that sometimes accompany technology-based communications, made it difficult in the defender's perceptions to build trust with their clients, build rapport with their clients. And the struggle to build trust often reflected in defenders feeling as if they weren't able to obtain the information they needed for hearings. So let's talk about communications in hearings. The digital divide was brought into even sharper relief for a lot of defenders that we spoke to when it came to communicating with clients in hearings. One defender relayed anecdotes of trying to do dry runs with his clients so that the clients, they could just get acclimated to the technology, kind of get familiar with it, see what it's like. And as he was doing these dry runs, particularly early in the pandemic, he realized that most of his clients lacked a tablet or a phone, and simply couldn't call in. And even if they did have a tablet or a phone, they weren't used to using this type of technology. I think it's really important to note at this time that youth use technology in a way very different to adults. In an age of texting and social media, they're not, kids just don't do video calls that often. It wasn't normal before COVID, and they barely ever talked on the phone. That was also not something that was necessarily normal for adolescents to do before COVID. And so even if they could get on the hearing, they weren't accustomed to really engaging in this manner where their face really is being scrutinized and their voice is being scrutinized via technology. And so that caused that it became very difficult to communicate because the arsenal of tools that a defender would typically use when having this type of fluid communication with a client, say, a nudge to the shoulder or a pat on the back, just weren't there. And you couldn't exactly lean over to your client and whisper, hey, you need to look at the video camera, because you can't lean over, there's nobody there. And so those little ways of communicating, those little ways of trying to make sure that that the kid was going to have as smooth a hearing as possible, suddenly was not available to defenders. And there was a lot of scrambling and a lot of creative solutions to this, but nothing really substitutes for those in-person kind of micro interactions. There were also technical limitations to hearings that raised ethical concerns for defenders. At least one defender relayed an experience to one of our interviewers about being very concerned about what the record was reflecting in hearings, because their objections would literally go unheard because the video client that they were using could only handle one microphone being active at a time. And so it was very difficult then to raise objections in a timely fashion, because that defender essentially had to wait until the other party was done speaking before they could literally be heard. There were also concerns expressed from advocates over access to or recording of breakout rooms when it comes to confidential communication with their client. And many defenders expressed as if they felt like they had a choice between communication and confidentiality. And that is not a tenable, frankly, it's not a tenable position for defenders to be in when you're engaging with these types of hearings, especially when your client's liberty is at stake. Defenders uniformly expressed that they felt as if these obstacles had a direct impact on their ability to provide effective representation, robust representation, and type of representation they thought that their client was going to be happy with. And so when it came to virtual hearings specifically, defenders cited concerns with their client around comprehension, the ability to understand what's actually going on in that hearing, the ability for their client to communicate questions and concerns to them in real time, because communication is a two-way street. A client needs to talk to an attorney as much as an attorney needs to talk to a client. And overall, the one of the biggest concerns that defenders expressed was that virtual hearings run a very real risk of dehumanizing their clients. Jamin, I thought it would be rather funny. I don't know if any of you are familiar with the screen cap on this slide with the cat. A lawyer didn't know how to turn the Zoom filter off on Zoom, and so showed up with a very photorealistic filter of something not human over his face. And it's funny. It is funny until you kind of think about it for a second and realize this is kind of what virtual communication does, right? It flattens interactions. You're looking at a screen. You're not necessarily looking at a human standing in front of you. And a lot of defenders really express concerns over their own capacity to express passionate arguments, zealous defense to a fact finder over essentially a TV screen, and the saliency that maybe an in-person hearing, physical presence would have that virtual hearings do not. And I know that Jema touched briefly on about collaboration in virtual settings, particularly kind of in the context of business and in negotiating and trying to get things done. And one of the things that research demonstrates is that when you're using mediated communications, whether that's a conference call over the telephone or something like Zoom or Skype or WebEx, the individuals who are on separate sides of the call, who are not physically in the same room, it's actually harder to negotiate because the parties will take more extreme positions than they would have otherwise. And for any of us who have sat in a juvenile courtroom, we know that that's not where we need to be, coming from extremes and coming to the middle. And to have that sense exacerbated, even inadvertently, it runs a very real risk for the capacity for defenders to do their jobs. And the very last thing that defenders were concerned with were the fact that some youth, some of their clients just didn't want to engage in virtual hearings. And especially in the early days of the pandemic, when we were still trying to figure out exactly what court was going to look like, what timelines were going to look like, when there was a lot of uncertainty and case delay, youth got frustrated very quickly. And some defenders relayed experiences to us that indicated that youth's calculus about what they would want to do with their case long-term changed. All of a sudden, kids who wanted to go to trial wanted to take a plea because they just didn't know what was going to happen, and they were not comfortable with this new medium. And so this particular issue, it's not just due to virtual hearing specifically, but communication overall. So given these obstacles posed by technology-based communications, what can we do? I think Marianne might have a few answers for that. Marianne, unfortunately, you're on mute.
Let's try to fix that. Thank you all so much for being with us this afternoon and for taking time to think about these issues about video conferencing and their impact on young people. I have to say we were really excited at the National Juvenile Defender Center that you all reached out and wanted to have this conversation because you're getting ahead of the curve. Right now, we're all still in the pandemic. People are grappling with the need to have virtual hearings because we don't have a choice. But what you're focusing on today is when we do have a choice, what do we do? So we're going to present a couple of recommendations, but they've all come out and they're really where you all are coming from. So first of all, as the National Juvenile Defender Center, our very first recommendation is we hope that courts and systems will recognize juvenile defenders as first responders to youth and youth rights during this pandemic and ensure that youth defenders are accessing PPE. They didn't talk about this. One of the scary things we heard about was many court systems around the country not affording PPE to defenders and clients, either in hearings or outside of hearings. We also want to be sure that when we look at what's happening during the pandemic, that we're affording virtual technology accommodations to young people and to their defense lawyers, and that we're ensuring that they have these accommodations inside and outside of courtrooms, as well as in facilities. You know, everything that Jayma and Carly just talked about matters, and it matters right now in terms of young people's lives and the decisions everyone's making. We also are, want to be sure that we're underscoring that as young people are prevented from engaging with technology effectively, that we as decision makers and advocates can do everything we can to make sure that young people have what they need and work to mitigate the limitations that exist for them. Currently now, we have to also recognize, and this really links to what's going to happen later, what are the due process deprivations that are occurring? So everything that Carly and Jayma just talked about, this infringement on the ability of young people and their lawyers to engage effectively and communicate about the hearing and young people's rights. So we want to be sure that as to the extent we have to continue to use these technologies, that they're private and confidential, that young people get to take breaks, right? How many of you have Zoom fatigue, right? There's all sorts of studies now on how hard this is. How hard is it for a young person to engage with a screen and really grasp the life consequences of these conversations that we're having about their lives? So taking breaks is really critical. And making sure that evidentiary hearings aren't conducted ever virtually unless the young person and their lawyer consent. So you're all focused on what happens after the pandemic. So let's talk about those very critical recommendations. So one, first and foremost, our recommendation is that we discontinue all virtual hearings since court convenience does not outweigh the 14th Amendment, due process considerations, and right to counsel. What we're saying with this recommendation is that we hope courts will not have policies that demand virtual hearings for any particular kind of hearing. It shouldn't be a presumption for virtual hearings. It should be a presumption against virtual hearings. If young people file a motion and affirmatively request a hearing because for them, their family, it is actually better for them, then we ask that courts consider the opportunity to have virtual hearings. We also want to make sure that as courts proceed, that the processes and procedures never infringe upon young people's right to counsel. Right now, we know that access to counsel is harder. And we want to make sure that as we come out of the pandemic, that we don't maintain policies and procedures that continue to make it harder for young people. Critically in this conversation, we talked about equality and disenfranchisement, and how this digital divide is hurting our young people, especially young people who live in communities where they don't have access to technology, and specifically Black, Brown, Latino youth who are engaging in the juvenile court system in disproportionate numbers everywhere. We have to recognize the harms of virtual proceedings and do whatever we can. And finally, after the pandemic, services, right? So we don't focus on post-dispo issues very frequently, but as many of you know, services are also being provided now to young people in the virtual space. So we're really focused on rights, access to counsel, liberty considerations, but we want to make sure that as we're coming out of the pandemic, there still is not going to be this idea that we're going to have services provided virtually. So we want to now have space and time for questions. I know that Betsy has 10 minutes built in. Then there are many more recommendations that are in the report. We hope that you'll go to the report and read them. We wanted to focus on those that were specifically focused on virtual technology and virtual proceedings. But please let us know if you have questions. And Betsy, we're open now to really hear from the community.